The jury came back yesterday after trial in San Francisco, in federal court in San Francisco, in the Oracle versus Google case that has, it was on a brief hiatus. The jury broke for a little while and just came back yesterday with the verdict after hearing all the evidence. And it was a unanimous verdict in favor of Google, upholding the proposition that Google's use of Java APIs, all 37 of them, was fair use. They went through all the fair use factors. They had a very dramatic and interesting trial with several high-profile witnesses and file cabinets, paintings that were supposed to illustrate what fair use is and isn't in usual contexts, all kinds of great, interesting tidbits from the trial. And if you haven't already delved into Sarah Jiang's live tweets from the trial, some of which have been compiled into Storify collections by her, they give you a real flavor of what the courtroom must have been like, and certainly her unique take on what she was seeing play out in front of her in the courtroom. So that's definitely worth a look if you haven't already been there, in addition to the copious other coverage of the case that's been going on for the last couple of weeks and in the wake of the verdict yesterday. So I guess I'll just go around. First of all, maybe we'll set the stage for this for people who haven't been following this case from its infancy. It's been going on for quite some time now. This is the second trial before this same judge in San Francisco. In the first trial, Oracle floated a bunch of other theories that are no longer in the case. Their copyright was in the case at that point, and there was a determination by the jury in that first trial that infringement happened. However, the jury in the first trial deadlocked on the issue of fair use, which is what they just tried and concluded yesterday. So then we had the Federal Circuit get involved. Actually, before the Federal Circuit got involved, the trial judge himself got involved and granted a routinely filed post-trial motion. And I should mention that we will see these kinds of motions get filed yet again, this time by Oracle, to have the judge take a look and see if he's going to let the jury's verdict stand. For various reasons, they may argue that that shouldn't happen. And in the first trial, Google actually prevailed on one of those motions and got the trial judge to say, hey, you know what? What we're talking about here, these APIs, they're not actually copyrightable. So this infringement verdict, that means nothing because it shouldn't be infringing as a matter of law. It's not something that infringement can apply to. So that is the issue on which the appellate court got involved, the Federal Circuit Appellate Court, and undid. Said, nope, sorry, we disagree. We think these things are copyrightable. So go back down, go back to trial, because we're going to need to get this fair use issue resolved. Because if this is fair use, then it doesn't matter that infringement took place. Google's in the clear. So that's the trial we just had, and that's the determination the jury just made. So with that all in mind, I want to go around and ask each of our panelists their impressions of the trial and their impressions of presenting a fair use defense in a circumstance like this to a jury. Let's start with you, Christine. What was your take on all this?
I think this decision is being hailed as a victory. But there are a couple of problems. First of all, this could be appealed again to the Court of Appeals for the Federal Circuit, and that was the court that you mentioned already. Denise had overruled the district court's finding that the APIs were not copyrightable. So this could again go back to that court, and I think that it will. I think that Oracle will probably appeal. And then the second problem is that although this decision is being lauded as a victory for developers, it's not as good as a finding that APIs are not copyrightable. So this is a finding that in the specific instance, what Google did in developing its Android operating system was a fair use. And of course, Google had all of its resources and all of its lawyers to do a 2-week trial, and it was extremely well done. And so that jury could find fair use. That doesn't mean that every other developer will be that successful in a claim of fair use. And because of the unpredictability of a fair use determination, there could be a chilling effect. So it may be that developers won't see the green light in the way that we're talking about right now, because of the fair use finding that they would have seen had it been a finding of no copyright protection for APIs.
That's right. You put that so well, Christine. It precisely encapsulates what's going on here. And as we often reiterate on the show, fair use is nothing if not a crapshoot. Right. The factors are complicated. They're difficult for juries and courts to understand and apply. They shift in each case. In looking at all the evidence that came in this case, there was no way to ballpark which way the jury was going to go on that fair use issue. It could easily have gone either way. So it is no guarantee that others similarly situated are going to get the same kind of outcome on any kind of consistent basis. And also, just to procedurally note, the question that actually, as this whole procedural history of the case was winding along, Google asked the Supreme Court to get involved on this copyrightability question. The Supreme Court declined. It'll have another shot at that once Oracle does, and I'm pretty sure they will too, Christine, take this up on appeal one more time. Once we've had the appellate court's final, the appellate court won't revisit its determination on copyrightability. But once the appellate court has had its final say, that's when any party who wants to take issue with any part of that determination can and probably will ask the Supreme Court to get involved and take up that copyright issue. There's no guarantee the Supreme Court will, but it's an interesting and important issue. And if the Supreme Court took it up, then we could get perhaps more certainty and give parties something other than this wishy-washy, totally unpredictable fair use opportunity, which is what they've got now.
That's right.
Yeah. So, Mike, what's your take?
I think this is a hugely important decision. I think it's hard to overstate the significance of it. Something that just struck me with Professor Farley's comment is my understanding is the first go around, the case was appealed to the Federal Circuit because there were patent claims involved, and of course under the federal statutes, the Federal Circuit would have jurisdiction over any decision involving patents. Now that the patent claim is no longer in the case, Professor Farley, would this go to the Ninth Circuit instead of the Federal Circuit, or is it going back to the Federal Circuit that heard the appeal the first time?
I think it's going back to the Federal Circuit. It's a good question. I hadn't really thought about that. It's interesting that we think of the Federal Circuit as being expert in intellectual property law. Of course, it's much more expert in patent law than in any other areas of intellectual property law. And in copyright law, it's the least expert. I think certainly the Ninth Circuit, the Second Circuit, the Seventh Circuit are much more expert in copyright law issues. And with regard to fair use issues in particular, that's been an area of law that has developed such nuances and sophistication as we saw in the Google Books case that was just decided last year in the Second Circuit. So I think it will go to the Federal Circuit. I don't think they're the best circuit to hear such an important case. But the silver lining in that is that initial ruling on API being copyrightable is only the law of the Federal Circuit, right? It's not the law of the Ninth Circuit, of the Second Circuit, the Seventh Circuit, other circuits. So, that's one bad decision, and it's just one.
Mm-hmm. Someone in RFC, Rev. Dan O'Metal, is proposing a solution to all of these legal maneuverings and where it goes next and whether the Supreme Court gets involved and how it's all resolved. He thinks that Google should just buy Oracle at this time without too much FTC or SEC fuzz. It's an interesting idea.
Well, there's an
Stranger
interesting
things have
fact here.
happened.
Yes,
So
please tell.
Oracle, they sought damages of $9 million, but they bought Sun Microsystems for $7.4 billion.
Yes, thank you.
So, yeah, the numbers seem out of whack.